worship.
It is 8:36. We'll go ahead and call this meeting to order. Ms. Fletcher, if you'll call roll, please.
Sure. Commissioner Mike Ayers-Mendez,
Present.
Commissioner Tom Butler,
Here.
Commissioner Dr. Ray Callis,
Present.
Commissioner Helen Collier, Commissioner Rick Figueroa,
Here.
Commissioner Dr. Weston,
Here.
Commissioner Yurko,
Here.
We do have a quorum present. If I could get a motion to excuse the absence of Commissioner Helen Collier.
So moved.
Second.
A motion is second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Let's move on to C, public comment. At this point in time, if there's anyone that wish to speak to the commission about an item that is not on the agenda, once we get to that agenda item, you'll have the ability to speak then if you would like. But if there's anything outside of the agenda you'd like to speak, you have 3 minutes in which to speak to the commissioners. If there's anyone here, please come forward. Seeing none, we'll move on to item D, executive session, consultation with commission attorney pursuant to section 551071 of the government code to receive a legal briefing on pending and contemplated litigation, advice from commissioner's attorney on legal matters authorized by 551071-2 of the government code, and our section 551074 of the government code, discussion of personnel matters. I would make note also that we would probably exit executive session somewhere around 9:30, 9:45 is what I'm anticipating. At that point in time, when this meeting was scheduled, Commissioner Callis was not present. We didn't have an objection from any of the commissioners, so we set the meeting date for today. Found out later that he has conflict. He's also the president of another statewide board, and he has a meeting today at 10 o'clock. So when we come back, you'll probably see Commissioner Callis not present, but it's because of the fact that he has another meeting he's got to go downtown for. So I did want to make note of that and let you know that he's also very busy. Actually, he's busier than we are, I think. So, but he will probably not come back with us, just so you know, so everybody be aware of that. So
Thank you.
at this point in time, we'll enter into executive session. Meeting. Executive session done. Is there any action to be taken out of executive session at this point in time? I'll entertain a motion.
Deborah.
Motion for, with that one?
Anything out of executive session?
Yes.
Yes, I'd like to make a motion to support a decision to remand the case. We have the O'Hara case
Okay.
that we had denied its motion for rehearing. Is that the one we're discussing? And I was going to make a motion that we support a decision by our general counsel if they need to settle or make any decisions in that matter.
There was a recommendation by general counsel, if you don't mind stating that recommendation that was brought forward to the commission.
Yes, sir. The proposal would be to agree to a settlement before the court that would remand the case back to the agency for a SOA hearing.
We have a motion.
Second.
Second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. So we have our marching orders. Any other items to be discussed out of executive session? Let's go on to item F, approval of the minutes. Commissioner, you have the minutes before you. A motion to be in order to accept.
Move to accept.
Second.
A motion and second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number, let's go on to item G, contested cases. We'll go ahead and get started on these. The first one up before us is Assad Corollas. And we have Aaron Heath coming for us. We're a newbie.
Good morning, Commissioners. My name is Aaron Heath, and I am a prosecutor with the Enforcement Division of the Texas Department of Licensing and Regulation. The department brought this case against Assad Carlos as a result of a department sting operation to catch unlicensed air conditioning and refrigeration contractors. In the proposal for decision, the administrative law judge found that Mr. Carlos did not offer to perform unlicensed air conditioning and refrigeration contracting and recommended that no penalty be assessed against Mr. Carlos. The ALJ made a witness credibility determination and found credible Mr. Carlos' testimony that he only went to the sting operation site to install a window air conditioning unit, which does not require an ACR contracting license. The department was previously unaware of this evidence, which was presented for the first time at the SOA hearing. And for this reason, the department is recommending that you adopt the proposal for decision issued by the ALJ and assess no penalty against Mr. Carlos. And I am available to answer any questions. Thank
Is
you.
anyone here representing Mr. Carlos? Or Mr. Carlos himself? We have a recommendation to accept the PFD as presented.
So moved.
Second.
Motion and second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 2, Maria and Anna Hubbard. She has requested a continuance.
That is correct. She has requested a continuance, and we do not oppose that.
Okay, and so we have no opposition by the enforcement, so we'll move that to the next meeting.
Okay, thank you.
Thank you, sir. Item number 3, Jose Longoria. Mr. Sharp.
Morning, Mr. Chairman, Commissioners.
Morning.
Mr. Sharp.
Before I go, I would like to ask if we could recognize that today is the National Day of the Deployed, intended to honor those service members and their families who are deployed.
So let it be recognized.
With that little
here.
commercial, then I'll move on to the next.
Thank you for bringing that to us.
Thank you.
To our
Appreciate it.
attention, that's important.
The respondent in this case is Jose L. Longoria. He has a journeyman electrician license with the department. The administrative law judge recommends that you deny the license renewal application and revoke the license because of Mr. Longoria's criminal history and because he lacks the honesty, trustworthiness, and integrity necessary to hold the license. And this is his criminal history. In 1993, he was convicted of assault and put on probation for 2 years. He was 19 years old when he committed that offense. In 1998, he was placed on deferred adjudication community supervision for 6 years for the offense of kidnapping. In 2009, the department licensed Mr. Longoria as an electrician. And in 2010, he was placed on a deferred adjudication community supervision for 5 years after pleading guilty to the offense of possession of a controlled substance with the intent to deliver. Now, that's not a guideline crime. It's not directly related to the duties and responsibilities of an electrician, so the department took no action against his license at that time. His community supervision ended in January of 2013 for that offense. Less than 5 years after that, when he was 41 years old, Mr. Longoria committed the offense of attempted aggravated assault with a deadly weapon. And in March 2017, he pled guilty to that, and the court placed him on deferred adjudication community supervision for 2 years. It's notable that he committed those two most recent offenses while he was licensed as an electrician. He submitted his license renewal application in September of 2017, 6 months after he was placed on deferred adjudication community supervision for that aggravated assault with a deadly weapon. On that renewal application, he answered no to the question that asked whether he had been placed on deferred adjudication since his last license was issued. And his most recent renewal prior to that was in 2016, August of 2016, so the answer should have been yes. The ALJ concluded that Mr. Longoria currently lacks the fitness and honesty and integrity and trustworthiness to hold an electrician license. The ALJ recommends that you deny Mr. Longoria's license renewal application and that you revoke the underlying journeyman electrician license. The department asks you to adopt the PFD.
Is anyone here representing Mr. Longoria? We have a recommendation by enforcement to accept the PFD as presented by the ALJ.
Make a motion?
Second.
A motion, a second. All in favor, signify by saying aye. Aye. Those opposed, motion carries.
I'm opposed.
I'm sorry, make it 4-1. Item number 4, Matthew Tago. Mr. Sheriff. Thank you, Ken.
Commissioners, good morning. My name is Michael Shirk. I'm representing the department in this matter. With me is Mr. Quitron. He's one of the inspectors who testified at the hearing in this matter. This case arises out of an inspection of a vehicle storage facility performed by Inspector Tron on September 29, 2015. Based on the inspector's findings, the department charged the respondent with 3 violations and proceedings conducted at the State Office of Administrative Hearings on April 25th of this year. The 3 charges against respondent included his failure to include a notice of rights in a second notification letter, which was sent to the vehicle owner and the first lien holder, respondent's failure to maintain legally required insurance for the 9-month period May 15, 2015 until February 25th, 2016, and respondent having illegally charged credit card processing fees, its performance of services in consideration for the collection of impoundment fees, and its charging a notice fee without having even sent notice. The administrative law judge, amazingly, found the department failed to prove the first 2 allegations. I'm requesting modifications to the proposal for decision such that the first 2 violations which have been alleged are found and administrative penalties are assessed for each. The first violation, failure of a second notification letter to have a notice of the vehicle owner's rights, was not disputed. In finding of fact number 12, the administrative law judge stated that the notice failed to give a vehicle owner notice of his or her rights to a hearing before a justice of the peace. And on page 5 of the proposal for decision, the administrative law judge expressly noted that, quote, respondent did not dispute that the incident occurred as alleged. Amazingly, however, the ALJ wrote in the proposal for decision at page 7, quote, staff did not prove by preponderance of the evidence that respondent failed to provide the notice of a vehicle owner's rights. And he noted that while the second notice did not include the notice, he found respondent's testimony credible, that omission of the notice was an error and that respondent intended no harm to the vehicle owner when he issued the deficient second notice. This is striking in 2 regards. First, respondent did not testify or present any evidence. In fact, respondent was not even present. Only his attorney was present, and his attorney did not introduce any evidence whatsoever. Throughout the proposal for decision, the administrative law judge relies upon and indeed paraphrases what he refers to as respondent's testimony, but respondent was not present. The facts are not in dispute. Respondent issued a second notification letter which failed to give the vehicle owner any notice whatsoever of his rights to have a justice of the peace evaluate the legality of the tow or the fees imposed by the respondent. The legal duty of towing companies and vehicle storage facilities To give vehicle owners notice of their rights to appear before a justice of the peace court is an essential legal right and integral to the department's efforts to protect consumers. It is a simple process by which vehicle owners can promptly receive refunds, and it takes some of the pressure off of the department to prosecute bread and butter towing cases. Failure to give notice of a rights in the second notification letter is a Class D violation, and we're requesting that a $1,200 penalty be assessed for that violation, which is the fixed penalty under your enforcement plan. The next violation alleged and proved by the department was respondent's failure to maintain insurance coverage for the period of May 15th, 2015 until February 25th, 2016, a 9-month period where the VSF went without any insurance. For obvious reasons, the maintenance of insurance is essential for the protection of consumers, and this is reflected in your enforcement plan, which classifies a failure to maintain insurance as a Class G violation. Investigator Tron testified that after a review of the records and information respondent provided during the inspection, and based upon his review of official department licensing records maintained in our Texas Occupations Online Licensing System, or tools, he concluded that respondent failed to maintain insurance for that period of time. Mr. Tron, as are all of your inspectors, is a professional who has received training and acquired skills in order to accurately evaluate violations of law. In addition to Mr. Tron's testimony, the department introduced and the administrative law judge accepted without objection the department's records establishing respondent's lack of insurance. However, again, the administrative law judge made his ruling based on the testimony of respondent, but as noted, the respondent was not even present, and his attorney did not introduce any evidence. The entire third paragraph of page 6 of the proposal for decision is devoted to respondent's purported testimony and his assertion that, quote, the department records were inaccurate because its insurance never lapsed. The administrative law judge also quoted the respondent as having said, as also having noted that he, that is the respondent, properly carried the legally required liability insurance. Incredibly, the administrative law judge denied the department's allegation based on this ghost testimony. Mr. Tron testified that during the inspection, the respondent provided a copy of a certificate of insurance, but that Mr. Tron does not accept these by themselves as adequate proof of insurance because a person can have a certificate of insurance, can have a certificate issued by his insurance company and then stop making payments, but still has possession of the certificate of insurance. Mr. Tron relied upon our records, which reflect more accurately the status of an insurance policy, and those records, department records, were introduced in evidence establishing this Class G violation. Therefore, the department made a prima facie case that respondent failed to maintain insurance as required by law. Respondent could easily have provided evidence that it was in fact insured for the 9-month period at issue, but chose not to provide any evidence. In addition, our rules 16 TAC 85-453 provide that a person who has had an inspection performed on their facilities has 10 days to provide verification that corrective action has been taken. No verification was provided, and again, no evidence was provided at the time of hearing that insurance was in place. I'm requesting, therefore, that the proposal for decision be modified to reflect a finding that respondent failed to maintain insurance as required by law for the 9-month period from May 15, 2015 to February 26, 2016, and that a penalty of $3,000 be assessed, which again is the fixed amount established by your enforcement plan for a Class G violation. The administrative law judge did find that the department proved its case with respect to impermissible fees and charged the respondent a $1,200 penalty. In conclusion, I request that the Commission modify the proposal for decision to find that respondent failed to provide legally required notice of rights in a second notification letter. This is a Class D violation for which a $1,200 penalty is required under the enforcement plan. I'm also requesting that the Commission modify the proposal for decision to find that respondent failed to carry legally required insurance for the period of May 15, 2015 through February 25, 2016, and assess a $3,000 penalty, which is required for a first Class G violation. These violations, along with the one found by the administrative law judge, would bring the total administrative penalty to $5,400. The administrative law judge's findings were not based on evidence gathered during the hearing and are simply inexplicable. I decided that the department would be better served by bringing the case directly to the commission rather than filing exceptions, because the PFD was such that I saw no possibility that the administrative law judge would change the erroneous conclusions that he had reached. Of course, there's no requirement to file exceptions to these cases, and the commission is free to make the modifications requested by staff today. If you have any questions of me, I'm happy to answer them, and Mr. Tron is here also to review the testimony that he gave during his hearing.
Any questions, Mr. Shirk? I'm sorry.
The PFD as written would establish a $1,200 penalty for the improper charge.
The PFD as written, yes, sir.
Okay. Thank you, Mr. Tron, for your work for the department. We don't often get to see inspectors one-on-one, and so it's a great opportunity for us to say thank you for all that you've done. We appreciate the hard work that you do representing us out there in the community, and y'all do a great job.
Is anyone here representing Mr. Tago? Or Mr. Tago himself? Commissioners, questions? If not, a motion will be in order. Any questions of Mr. Tron also, if you'd like?
Make a motion that we recommend the PFD as recommended by the
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
All opposed, no. Motion carries 4-1.
Thank you,
Thank you,
Commissioners.
Mr. Shirk.
Thank you, Mr. Tron.
Mr. Thielen.
Mr. Shirk, thank you.
You're a busy man. Let's go on to Donald Burton Jordan. Is Mr. Jordan here? Anyone here represent Mr. Jordan? Proceed.
Good morning, Commissioners. My name is Trevor Thielen. I represented TDLR at the SOA hearing against Donald Burton Jordan. This is not one of the criminal history license revocation cases you usually see me present. The department alleged unlicensed electrical contracting in this case. Before the hearing, I believed we could prove our allegations by a preponderance of the evidence. However, the testimony and evidence was less persuasive than I anticipated. The ALJ proposed a finding that the department's evidence did not meet the burden of proof, and we agree with that conclusion. I recommend you adopt the PFD as written. Are there any questions I can answer?
Are there any questions for Mr. Thielen? Is anybody here representing Mr. Jordan? Is there an attorney or anybody present for Mr. Jordan? No? Members, we entertain a motion or any discussion?
Make a motion to adopt the PFD as
Second.
written.
Okay, we have a motion and we second. All those in favor signify by saying aye.
Aye.
The motion carries and the ayes have it. Continue, Mr. Thielen.
Mr. Maldonado's case, Trevor Thielen with enforcement. We recommend that you accept the ALJ's amended proposal for decision, deny Ray Maldonado's journeyman electrician license renewal application, and revoke that license based upon the danger indicated by his criminal history and because he lacks the required honesty, integrity, and trustworthiness to hold the license. In May 2016, at age 39, the respondent was working as an electrician inside a customer's home when he stole diamond earrings worth about $15,000 from the home. The respondent's employer told the police that they had received other complaints about missing property from the homes of other customers where respondent had worked. When initially questioned by the police, the respondent denied knowing anything about the theft. However, after waiting over a month, the respondent attempted to sell one of the diamonds to Dallas Gold and Silver Exchange. Though he apparently tried to cover his tracks by removing the diamond from its gold casing and only selling one of the diamonds at the time, the diamond was identified by a diamond map the owner had made. When surveillance footage of the sale was examined, it clearly showed respondent as the seller. After police contacted respondent's attorney later arranged for the return of the other diamond to its owner. The respondent has not yet refunded the $1,000 the exchange paid him for the diamond. The respondent pled guilty to the felony theft offense in January 2017 and received deferred adjudication probation. However, on his renewal application just 2 months later, he denied having pled to or received deferred for any offense since his last license renewal. At the hearing, the respondent told the ALJ that his electrician helper at the house that day was the real thief, and he only pled guilty to keep this helper from going to prison. He said that selling the diamond was an intentional effort to get it back to its owner. He failed to explain why that was a better plan than just returning the diamonds to the home or to the police, and he couldn't even remember the last name of the helper who he was willing to plead guilty for. The respondent found that the ALJ found that the respondent's explanations were, quote, improbable and not credible, but respondent insisted he was telling the truth. When the department took respondent at his word and asked him why he apparently thought it was okay to lie about being guilty to the district court when he pled so, he told the ALJ that he only tells the truth to, quote, people who matter, and that the ALJ and the rest of the people at SOA that day were the only people who mattered. Theft offenses are guideline crimes closely related to the purpose for acquiring an electrician license. Importantly, this offense took place inside a home the respondent was performing electrical work in at the time. Continuing to hold his license could afford him more opportunities to commit similar offenses. The respondent's multiple lies on his application to the police and to the ALJ at SOA while under oath strongly demonstrate he does not have the required integrity, honesty, and trustworthiness to hold a license. We recommend the Commission accept the ALJ's amended proposal for decision, deny the renewal application, and revoke the license.
Are there any questions of Mr. Thielen? Is anybody here representing Mr. Maldonado? Commission members, what would you like to do?
Second.
We have a motion to accept the amended PFD as recommended, and we have a second. All those in favor, please signify by saying aye.
Aye.
Those opposed? The ayes have it, and the motion carries. Mr. Thielen, the Kirkland case.
Oh, the Kirkland case, excuse me.
That's the next, oh, I'm sorry. Oh,
Jessup.
forgive me.
Jessup.
Jessup, I'm sorry. Mr. Jessup. I do have a public comment form from Mr. Michael Jessup Jr. Is that you? Yes. Okay, great. Thank you for being here, Mr. Jessup. Mr. Thielen, please.
Trevor Thielen with enforcement. We recommend you accept the administrative law judge's proposal for decision and deny Michael Jessup's apprentice electrician license application. Between 2013 and 2015, the applicant committed 9 offenses, including 2 thefts, 1 burglary of a vehicle, and 2 counts of fraudulent use of identifying information. One of those last offenses involved the applicant using an elderly woman's Lowe's credit card to buy construction tools. All of these are guideline crimes for electricians. The other offenses involved an escape from custody and possession of methamphetamine, the drug that the applicant told the SOA judge fueled his offenses. He went to prison in 2015 and got out in June 2017, less than 2 months before filing the application you are considering today. On that application, he denied having any criminal history, even though he was on and will remain on parole until November 2020. We sought to deny the license based on the theft, burglary, and fraud offenses and the false answer on the application and the short amount of time he's been out of prison. The ALJ did find that the applicant did not knowingly falsify the application. However, the ALJ ultimately found in favor of the department. The ALJ noted the applicant's letters of recommendation, none of them from law enforcement, as well as his apparently genuine efforts to improve his life. The ALJ also found that the seriousness of his offenses and the need for additional time to establish a record of good conduct since his recent release from prison meant that he did not prove his fitness for the license by a preponderance of the evidence. She recommends that you deny the application, and the department agrees. Are there any questions I can answer?
Any questions for Mr. Thielen? Okay, Mr. Jessup?
Good morning, Commissioner. All these offenses that I'm being prejudged on and everything is based off of, I was 19 and 20 years old. To me, I was still a kid that made poor, rational decisions. I'm 26 now, I'm going on 30. I have goals and dreams and accomplishments that I want to achieve. I want to be a journeyman electrician, and one day I want to be a master electrician. And in order for me to obtain the license and to achieve these goals and to get where I want to be in life and to go down that path, I have to obtain my apprentice license, which is a stepping stone in order for me to get there. I've been working for a company now for 2 years straight since I've been released from prison. They're willing to send me to college, they're willing to send me to school, they're willing to go the whole 9 yards to give me a real chance at life and to allow me to be somebody valuable in the company. But in order for me to be a part of that with that company, I have to have an apprentice license. And that's why I'm here today, is to be granted my apprentice license. And, you know, I have a family to provide for, I paid my debt to society. I did 4 years in prison. These crimes I committed, I was 19 and 20. I haven't committed an offense since I was 19 or 20. Since I've been out, some of these offenses that I was on probation for have been cleared off my record because I followed all the stipulations and completed everything successfully. So some of these felonies that he has on file no longer exist because I finally had the time behind me to remove them and complete my circumstances and stipulations successful. So, and I'm here today just to ask y'all for some leniency and mercy, and please do not let my past mistakes define the rest of my life. And just please give me a real chance at life so that I can have a career and live a normal life and be a law-abiding citizen so that I can provide for my family and have a normal life and, just take care of my family and go from there.
I have a question.
I'm sorry, I'm kind of nervous, I'm sorry.
No, don't be.
I'm confused. Your March 2014 deferred adjudication offense?
Yes, ma'am. All those offenses.
Did they end up finding you guilty and combining it with the time served, or what did they do?
They put me on deferred probation, and at that time I ended up going to prison. So they ran it concurrent with my prison sentence. I actually got out of prison. They violated me because I went to prison. When I got out, I hired an attorney. They seen that I was on the right track. I took them all my certificates that I took while I was in prison, that I took upon being released. I took them in front of a judge, and we presented everything to them, and they said, okay, we're gonna reinstate your probation. We're gonna let you complete it successfully. They waived my community service. I paid the amount of money that they wanted me to pay, and they said, okay, now we're gonna discharge you successfully. And so we were able to go back in front of a judge. They seen that I paid everything that they asked me to pay. They waived the community service, and they granted my release from supervision. And at that point, the felonies that I took deferred probation for were supposed to be expunged or removed since I completed the stipulations successfully.
So on this, it says that your offenses occurred March 26, 2015. Is that accurate?
Yes, sir.
But you're 26.
Yes, sir.
So you were 23 when this happened?
October, I think I turned 23 while I was in there.
By my count, 3 of the offenses took place when he was 20 years old, 4 of them when he was 21, and 2 of them when he was 22.
Okay, so I was 20.
Not
Sorry,
19.
it's been, I can't keep up with it. It's been so long, I can't keep up with it exactly how it was, but I know what's going on. Like, I'll discharge parole this time next year, or in 2020, so I know that'll be 6 years from my offense.
Mr. Jessup, do you not find that disturbing that you state, I've had so many I can't keep up?
It's embarrassing.
I apologize for coming in later.
No apologies, no problem. Mr. Jessup, is this your family back there?
Yes, sir, it is.
Well, welcome. It's an odd thing because we have to protect the citizens of the state, and we also have to balance that with allowing people to earn a living to provide for their families. And so it's an odd position that you put us in. And so whatever happens today, I want to encourage you to stay on the right track. I can't think of a greater motivation than what's back there and staring you in the face every day. You have to love them more than you do being away from them. And if I lived 1,000 years, it wouldn't be worth, looking, not having the ability to see my son's face every morning. I would trade that for 1,000 lifetimes. And so you've got to stay on the right track. I don't know that we're going to vote for you to have your license today, but there are plenty of things that you can do to earn a living without this license if it goes against you today. And so I'd like to first say that I'm glad you're here. It takes a man to do that, but it takes a man to get up every day and go to work to feed his family. And that's what you need to be at this point, okay? I think that's probably all I really need to say.
Any other questions or comments from Mr. Jessup?
Mr. Jessup, I do. I'm going to have to agree with Commissioner Butler. I think it's remarkable, and it speaks volumes that the court decided to grant your deferred adjudication, that you completed it and discharged it despite the attendance. And I would love to give you a 10th chance, or whatever the number is at this point. but I just think it's too soon from your release. And I would like to see you stay on the straight and narrow and come back before us and resubmit that application in the future, once you've had a little bit more time to prove yourself on the outside.
Yes, ma'am. Can I make a comment? Since I've been released, I've been out 2 years, and in order to become a journeyman, you have to have 8,000 hours. As of right now, I'm close to 4,000 hours. So, in this process, of going on over a year now, and if I'm already halfway to my goal, which is to become a journeyman licensed electrician, but if I'm not granted this license, then that sets me back further from the 2 years that I'm already behind, and I can't be credited for any of the hours that I have accumulated over these last 2 years. If I don't have an apprentice license, then everything that I'm working hard for and I'm getting up for to go to work for every day is not even accounted for, or I'm not being rewarded for.
Well, and I understand what you're saying, but again, as we mentioned earlier, we are not putting you in this position. You put yourself in this position.
Yes, sir.
And so while it's commendable that you have 4,000 hours towards your journeyman, which I think that you need to continue to strive for, I concur the sentiments of Commissioner Yurko to state that it's just too soon. You have too many crimes that have occurred within the last few years, and you've only been out for a couple of years. I hope you also know that if this commission votes to not grant your license and to accept this PFD as presented, it doesn't mean that you're shut out completely. You can turn around and come back and apply again in the future. Don't think that this is it. If this is the route that you want to be in, if this is the industry that you want to be in, I would say that you need to continue to seek that goal and make it a goal for you and for your family. But understand also, we have also a duty to the citizens of Texas to ensure that they're protected. We have plenty of individuals come before us with a criminal background that want to get a license that we have said no to. And I can tell you that my vote's going to be no. I don't, at this point in time, I don't believe you need to have a license. I think you need to continue to work, do what you need to, find areas to get to work, to provide for your family. But the unfortunate part is that while I hear what you're saying about the number of hours that you put forth in wanting to get that journeyman electrician, you placed yourself in this position. You placed your family in this position. And our responsibility is to ensure the protection of the citizens of Texas.
Yes, sir.
While I would love to have you get back to work, in this industry, I just think it's too soon.
And those hours don't go away. 4,000 hours are 4,000 hours.
Well, unless I have an apprentice license number to put them under, then they can't be counted for.
Go down the road, though. Down the road, you can get that number. If you stay on the straight and narrow, you have a golden opportunity ahead of you. Keep doing what you're doing. If this is really what you want to do, you can prove that to us.
I mean, it is. Before I went to prison, I didn't know my purpose in life. I was lost. I wasn't
That
caught
purpose
up
is
in
sitting
it.
right behind you. A job is just what you do to feed them, to feed your purpose. That's your purpose right there. That's your purpose. A job is just a job. There are thousands of jobs out there. There's one family that you have. Okay?
Yes, sir.
Any other questions or comments, Mr. Jessup?
I think, I have a theory. Don't try to unexplode a bomb that's gone off, right?
Yes, sir.
Bomb's gone off. Own it. Own it, because I think your strongest strength could be what your history was. It could be your weakness. In other words, the rarity of somebody to just come back from where you come is a story. That testimony that you're going to speak, not just to your family, but beyond, can be your power. So don't run away from it. Embrace it, own it, and run through it, because the bomb's already gone off. So denial is not, in my mind, is not even an option anymore. So my advice is to own it, because your story is compelling when you get through it. The other side of it will be just more so compelling than the average guy who just became a journeyman electrician. And I think that people will be attracted to that, because you've been refined by that fire. So granted, it's a hell of a way to be refined, self-imposed, right? But on the other side of that, it means the value exponentially of you as a person can be tremendous if you choose to walk through it.
Thank you.
Any other comments for us, Mr. Jessup?
If I was going to go back to being the person that I was before, I've been out now 800 days approximately, roughly. I have every opportunity to steal, to steal something, to take something that's not mine. Every opportunity that's in front of me every day. When I go to a gas station, when I go to a grocery store, when I drive a company truck, when they give me the debit card to get gas, when they give me the debit card to get material, I have an opportunity to go back to the person who I was before I went to prison. Every day I have that opportunity in front of me. If you look at my track record 5 years ago, whatever it was bang, bang, bang. There was never no point in time or time frame to where I didn't commit a crime. But it's been 5 years now since I committed a crime. I've been out 2 years now, and I haven't committed a single crime. I mean,
And all I can tell you is continue to prove that.
I just want to note, you keep saying 2 years. It's been 1 year, 4 months, and 21 days by my count since he's been out of prison.
going on 2 years.
So all I can tell you is to continue to prove that. That's all you can do.
Mr. Jessup, we see people that are twice your age that are begging for their apprentice license. You don't want to be that guy. You don't want to be a 50-year-old man sitting in front of a board like this begging to feed yourself, okay? So yes, you have an opportunity to steal every day. Everybody in this room does. But you also have an opportunity to create a wonderful life for you and that little girl back there. That's the opportunity you have. That's the opportunity of Texas. That's the opportunity of being born in America. You have an opportunity to turn yourself into something grand, not an opportunity to steal. You wake up in the morning, it's a blessing, you're alive. A lot of people don't get that opportunity. So to say that's an opportunity to steal, man, you're hitting way off the mark. You have an opportunity to see this daughter of yours grow up into something wonderful, and you being by her side every single day of that journey. Now that's an opportunity worth $1 million. Okay? That's a real opportunity. Don't confuse that. Okay? That's looking at something to steal, that's a punishment. That's a hell that you live in your mind if that's what you're looking at. Okay? You find a job, raise your family. That's the wonderful life.
Anything else from you?
Nothing further?
A motion to be in order at this time? Or comments by the commissioners?
Who to accept PFD?
Second. We have a motion and a second to accept the PFD as presented. All in favor signify by saying aye.
Aye.
Those opposed?
Do you have a second?
Yes.
Okay, I didn't-
Motion carries. Mr. Jefferson, staff will get with you, kind of let you know maybe what your avenues are. At this point in time, based on what the commission had, is that, well, they'll give you what your other avenues are. You still have further administrative avenues to pursue. Don't think that this ends right here. The staff will kind of let you know where you're at. Okay? Thank you, sir. Appreciate it. Let's go on to item G8, which is for John Kirkland. Mr. Kirkland, come forward. Mr. Thielen, proceed.
Trevor Thielen with enforcement. We recommend that you accept the administrative law judge's proposal for decision, deny John Kirkland's journeyman electrician license renewal application, and revoke the license. In 1994, at age 36, the respondent climbed on top of an outdoor air conditioning unit where he could see and be seen by an adult female resident through the window of her apartment. And then he undressed and pleasured himself. A year later, the respondent approached the same woman in the apartment complex's pool and removed his swim trunks. The woman then reported both incidents to law enforcement, who charged the respondent with 2 counts of indecent exposure. The respondent pled guilty to the 1994 offense and was placed on probation. As part of the plea deal, the respondent also admitted guilt in the second incident, in exchange for the court dismissing that second charge and punishing him for both crimes with a single punishment and a single conviction. For over 20 years, the respondent stayed out of trouble, during which time he obtained a journeyman electrician license from the state. However, in 2016, a homeowner discovered the respondent standing in the driveway outside his house at 1:43 a.m., nude and pleasuring himself. The homeowner told police that the respondent then walked across the street and repeated the behavior on his neighbor's porch while looking at their front door. When the police arrived, they found the respondent in only a bathrobe, playing on playground equipment at a nearby park. He ran from the police but fell down. And was apprehended. He admitted to the police that his wife had told him to stop this behavior, but also that he liked looking at himself in people's doors and that, quote, doing what I did is an addiction. He was convicted of evading arrest and put on a 2-year deferred adjudication for another indecent exposure. He pled to the indecent exposure on July 25th, 2017, the same day that he applied to renew his license. The ALJ agreed that the renewal should be denied and the license should be revoked because after weighing the seriousness of the offenses, the specific facts involved, the respondent's age during the latest offenses, which was 58, and the recency of the offenses and the lack of evidence of rehabilitation, the ALJ determined that the respondent may pose a continued threat to public safety and that employment as an electrician would create a situation where respondent would have the opportunity to repeat the conduct. The ALJ also based this recommendation on the respondent's lack of the required trustworthiness to hold the license and stated that he needs more time without reoffending to demonstrate that trustworthiness. The department recommends you accept the PFD as written. Are there any questions I can answer?
Any questions for Mr. Thielen? Mr. Kirkland, if you don't mind, state your name for the record. Go ahead and move that closer to you, sir.
John Kirkland.
Mr. Kirkland, the only thing that we can accept at this point in time is anything that was presented at the SOA hearing with the ALJ. Were you at that hearing?
Yes, sir.
Okay. So the only thing we can take into consideration, what was mentioned there, you can't bring anything outside the record
I
into
understand.
this. Okay? Go right ahead, proceed.
I mean, I understand what happened to me, and I told everyone it was an addiction, and I'm getting treatment through a therapist, which is required by Williamson County. I go every Monday and pay fees that I'm supposed to pay for treatment for this particular behavior. And I am on the right track to try and better myself so I can provide for my family the needs that have to be met. I've paid an enormous amount of money for this offense that has occurred to me, and I'm just willing to recapture my journeyman's license, and it looks like it's pretty doubtful. I'm on a deferred adjudication, no conviction. I got convicted for evading arrest, and up until this time, I mean, I'm still going to treatment and paying fees and fines, and in about 8 months, I'll be off probation.
Any questions or comments for Mr. Kirkland? Mr. Kirkland, your last offense occurred in October 1 of 2016?
Yes, sir.
You had one offense in 94, another one in 2016, is what we're showing here?
You're seeing, I think, in 2016, the evading and the indecent exposure, they were part of the same incident.
Right, okay. But they were actually, they were adjudicated in May 22nd of 17 and July 25th of 17. I think your comment of is very doubtful is based on the previous conversations that were held in the previous case. When you say it's doubtful that you think that you'll be able to get your license, or you simply know this commission, it hasn't swayed on my part. I think that this is still too soon.
Yeah.
You need to be able to prove that you're there to get out of the rehabilitation,
Yes, sir.
show that you are becoming a productive citizen of society.
I am.
Not so much work,
Yeah,
not so much electrician,
I understand.
but of society.
Right.
And the unfortunate part is that I would have to accept the PFD as written and deny your application, revoke it, and not have you get a license. Of course, as you know, you can apply again down the road, but I just think it's too soon. Any other questions or comments? If not, anything
So
else you'd like to say to us?
Deferred adjudication would not even, after I'm through with the probation and the treatment.
We don't, you don't, as far as this commission's concerned, this department,
Yes, sir.
you don't have to complete deferred education to reapply. The staff can tell you when you can reapply again, based on the timelines.
Trevor had informed me that.
And then those are some of the things that they'll be able to tell you. Don't think that you have to wait for the deferred adjudication to end to reapply. They may be coincidental, they may not. But it's based on the timelines for us.
Okay.
So, but, depending on how this commission works and how they vote,
So it could be 3 or 4 years?
again, it just depends. I can't give you any certainty. I wish I could, but I can't.
I understand.
Okay? And plus, well, let's go through this first. Any questions for Mr. Kirkland? Anything else for us?
No, sir.
Okay. Mr. Thielen?
Just in answer to his question, it may be that a deferred 5 years after he successfully completes a probation, if it's not adjudicated. I can't remember if indecent exposure is listed as one of the alternate crimes that can be considered whether it's deferred or not. But generally, 5 years after you finish the probation, most of the
5
time.
years after?
Yes, we can't consider it. But what I think
Yes,
Mr.
I am.
Osman is saying is that even if that time isn't up and you're eligible to apply again, things get looked at based off of what time we're at when the application comes in. I'm just saying legally for that to be considered at
Yeah.
all, it
And
would
he-
take at least that long.
Yeah, and
Oh my
Mr.
God.
Kirkland, you can actually have this conversation with Mr. Thielen off of this. We're simply considering this PFD right now. The logistics of that, of when you can apply and everything afterwards, it can be discussed with Mr. Thielen. I can tell you that if you have any letters of recommendation from individuals, therapists, law enforcement,
A
clergy,
recommendation is-
anything like that would be helpful in your cause if you decide to apply.
No.
Okay?
Not now.
No, it wasn't presented, so we can't take it
I
now.
understand.
So, Commissioners, a motion to be in order. Any further discussion?
Second.
We have a motion and a second to adopt the PFD as presented. All in favor signify by saying aye. Aye. Those opposed, motion carries. Let's go on to item G9, Sammy Salazar. Is anyone here representing Mr. Salazar? Mr. Salazar himself? Mr. Thielen, proceed.
Trevor Thielen with enforcement. The department originally issued a license to Mrs. Salazar despite him having some crimes in his past. We now seek to revoke because he committed further offenses. The ALJ recommends revocation based upon, first, his criminal history, which includes 4 convictions for unauthorized use of a vehicle, 2 convictions for assault, 3 for possession of cocaine, 2 for resisting arrest, and 1 conviction each for attempted assault, criminal trespass, attempted forgery, and felony-level criminal mischief. Also, his false no answer to the criminal history question on his latest renewal application and his lack of the honesty, trustworthiness, and integrity to hold the license. We recommend you accept the PFD as written and revoke the license.
Any questions, Mr. Thielen? A motion to be in order.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item G10, Jorge Anorve?
Anorve?
Anorve. Anyone here representing Mr. Anorve? Mr. Anorve himself? Proceed.
Trevor Thielen with enforcement. We recommend you accept the administrative law judge's PFD, deny Jorge Anorve's apprentice electrician renewal application, and revoke that license because of the possible risk indicated by his criminal history, because of the false answer he gave on his renewal application, and because he lacks the required trustworthiness to hold the license. Before becoming licensed, Mr. Anorve was convicted of an assault, family violence, and possession of an illegal weapon, and had received deferred adjudications for continuous violence against the family, criminal mischief, possession of cocaine, and 2 additional assault family violence offenses, one of which involved grabbing and squeezing the victim's neck. The offenses were committed when Mr. Anorve was between the ages of 20 and 25. He obtained his license in 2015. On March 1st, 2017, he was convicted of attempted assault family violence and sentenced to jail time. He was 26 when he committed this offense. In November, he filed an application to renew the license and denied having any new criminal history. The license did not renew automatically, so this case will have to resolve the pending application. Mr. Anorve acknowledged that he has anger problems, but emphasized that he has completed anger management courses and other probation conditions. He provided no documentary evidence to back this up. In court, he stated that he gave the false criminal history answer because he was in a hurry and doing the renewal on a cell phone with a crack in the screen. This is different than the earlier reason he gave the department, where he said he answered wrongly because the offense occurred in 2016 and he was renewing in 2017. The ALJ did not accept either of these excuses and found the preponderance of the evidence showed he gave a false answer and failed to provide information requested by the department. The ALJ weighed the required factors and decided the deferred adjudications could be used as convictions because they indicated he has anger problems and a predisposition for violent response to confrontational situations that may arise when he's working as an electrician. She commended his progress on probation, but also noted not enough time has elapsed to show he has the trustworthiness required to hold the license. It's also important to note that many of the crimes the respondent committed occurred while he was on probation and while he was licensed, meaning that neither of those have dissuaded him in the past from criminal behavior. Just because the court or prosecutor chose not to revoke his probations does not mean he didn't violate those probations. The ALJ recommends you deny Mr. Norve's renewal application and revoke his license. We recommend you accept the PFD as written.
Any questions, Mr. Thielen? A motion be in order?
Accept.
Second. We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number G11, Edward Wayne Oldham. Is anyone here representing Mr. Oldham? Go right ahead.
Trevor Thielen with enforcement. We recommend you reject the ALJ's PFD and revoke Edward Wayne Oldham's vehicle storage facility employee license. We argue three distinct reasons why the license should be revoked. I'll deal with each in turn. One, we argued Mr. Oldham's license should be revoked based on his false answer on his renewal application. In August of 2016, Mr. Oldham committed theft, but he didn't plead to the offense until the middle of 2017, months after he obtained his license. He wasn't required to disclose the offense to us when he first applied because the charge wasn't final yet. However, when he applied to renew in 2017, he was required to disclose the plea, but he did not. At the hearing, Mr. Oldham's employer at the vehicle storage facility, Jerry Palmer, testified that Mr. Oldham told him about the case, but that Mr. Palmer did not relay that information to his wife, the co-owner of the business. Mrs. Palmer filled out renewal applications for all employees, and since she didn't know about the plea, she answered no to the criminal history question. With no evidence to contradict the respondent's evidence, this department acknowledged we couldn't meet our burden on this ground. 2, we also argue the respondent's license should be revoked because he failed to provide a criminal history questionnaire, a probation status form, or a written explanation for his no answer to our investigator, who requested this information in a letter mailed out to the respondent soon after he renewed. The respondent denied he'd ever received the letter, and Mr. Palmer noted that the respondent's address of record was the business, because Mrs. Palmer filled out the license application, and that sometimes their mail is delivered elsewhere, so it could have been lost. The ALJ's original PFD made erroneous findings that the department mailed the letter to the wrong address and based its conclusions on those erroneous findings. We filed exceptions, and the ALJ corrected findings of fact number 8 and 9, but still determined the department had not shown the respondent received our request for the additional items and did not make any further changes to the conclusions of law. Because of the unusual facts of this case, we don't contest the ALJ's determination on this second ground either. However, the third ground we argued the license should be revoked on was because the respondent's criminal history directly relates to his licensed occupation. Respondent pled guilty to stealing over $2,500 in auto parts from his employer's place of business, his prior employer before Mr. Palmer. Today, he is licensed as a vehicle storage facility employee, where his job necessarily creates situations where he is in complete control of the public's vehicles and their contents. The ALJ determined that the respondent's otherwise clean criminal history, the full support of his employer, Mr. Palmer, who says he knew of the charges from the start and supports the respondent anyway, the written recommendations provided by others, and the certificates showing that respondent has completed multiple courses on personal growth and advancement overseen by Mr. Palmer, showed that the respondent did not pose a continued threat to public safety or that continued employment would provide him with opportunities to repeat the violation. Because of this determination, the ALJ declined to consider the deferred as a conviction, barring it from being used as a basis to revoke the license. Despite Mr. Oldham's support for his employer and others, there's a clear opportunity for a person who has stolen auto parts from their employer's place of business to repeat the offense if they work as a VSF employee. We recommend you reject the PFD, amend findings of fact 30 through 32 and conclusions of law 14 and 16, and revoke the license. If you are inclined to vote in this manner, I can break down how to amend those to achieve this result. I'm also available for any other questions.
Any questions, Mr. Thielen? I can tell you I have a lot of them, I just don't know what they are right now. I find it very disheartening that the ALJ would have, would come to some of the conclusions that they came to, and not find that this is a direct connection to the industry in which he's in. And how previously we have denied people's license for falsification of asking a question if it ever occurred, if they've had any misdemeanors, felonies, anything, deferred adjudication occur. And when they answer no, we've turned around and said, well, that has to go with your honesty, trustworthy, and integrity. But this is written in such a manner that makes it difficult for us to change, although I think that you state that you may have the opportunity to do that, but it's difficult for us to be able to get there. I tell you, this is one of those that I just have a lot of heartburn on.
Mr. Chairman, this is Brad Bowman, General Counsel. Wanted to maybe clarify something I heard from the prosecutor. I think, if I heard right, the prosecutor is accepting the ALJ's findings with regard to the falsification of the application and not responding to the request for information,
That's
but
correct.
is instead asking you to change the PFD on the basis of the substance of the conviction and whether, or the deferred adjudication, and whether that renders the respondent unfit for a license. So I just kind of wanted to make that, in the exceptions, I think the exceptions focused on those first two issues rather than the substance of the underlying criminal matter and whether that would render the respondent unfit for the license. So I just want to make that clarification based on what I heard from the argument here.
And that's all correct. I did not focus on the third issue as much in my exceptions. In retrospect, I wish I had approached it differently. I spent a lot of time trying to correct the obvious factual mistakes that I thought that the judge made. And one of the reasons I think you can change findings 30 through 32 if you're inclined to do so is they seem to be a mixed consideration of finding of fact and law. They're about his fitness and the continued threat to public safety and whether or not the continued licensure may lead to respondent having the opportunity to repeat the alleged criminal conduct. And that's why I think those are distinct and within the Commission's power to change if you are inclined to do so.
Any questions or comments for Mr. Thielen? Attempt at a motion? The ALJ has ruled that that the license should not be revoked.
That's correct. Yes, that the renewal should be, yes, simply that it should not be revoked.
Mr. Chairman, this is Brad Bowman again. I do think that the Commission has some latitude to change the PFD in the way the prosecutor is suggesting, if you are inclined to go in that direction. I'm not arguing that
I'm
you should or
inclined to go in
shouldn't,
that
but
direction.
I just wanted to give you my perspective that I think you have that authority and discretion if you choose to pursue that, because it's really more of a legal determination as to whether the person is fit for a license based on the underlying criminal offense. And so I just wanted to.
And I can tell you, I'm inclined
Well, and
for
I'm
that.
relieved because I'm inclined, and I'm so inclined that I would make a motion with some assistance to draft up that wording.
Okay. The changes I would make are fairly simple. I would change finding of fact 30 to read respondent is not fit to hold a VSF license. 31 to say respondent may pose a continued threat to public safety. 32 to say continued licensure may lead to respondent repeating the alleged criminal conduct. And then also, I would change conclusion of law 14 to read respondent's deferred adjudication may be a basis for revoking his license because it may be considered as a conviction for licensing purposes and makes him unfit for licensing purposes. And then I would change the final conclusion of law number 16 to respondent's VSF license should be revoked.
Would it be okay for me to say I so move as recommended, or do you want me to repeat what I scribbled
I
down?
don't think it's necessary to
Okay,
repeat it if you
thank
agree
you.
with that.
This would be for the basis of revocation?
Yes.
Okay.
Just quick, I don't want to hear the prosecutor's comment. Why would the ALJ go this way? What was the?
I think
I find it hard to go against these guys because their fact-finding is meticulous, right? And we lean a little heavy on that.
well, and I'm speculating, but trying to follow the ALJ's conclusions here, I think he was touched by the respondent's testimony, by the firm, unwavering support from Mr. Palmer, his employer, who showed up and testified, frankly, as much, if not more, than the respondent in the case. And I think he also looked at the fact that this was his only criminal offense and wished to cut him some slack. If he was going in that direction, my preference would be that he find that the deferred can be considered, but then ultimately that the factors didn't require revocation. Instead, he found that and our laws are written a little confusingly because they kind of ask the ALJ to go through the same factors in every case regarding all the different, the age of the case and letters of recommendation, everything like that. But they doubly ask you to go through those factors, those same factors, when determining whether or not a deferred adjudication, which was what we had here, should be considered as a conviction, because you got to go through that two-step process if it's a deferred adjudication in this case. And I think maybe the ALJ was troubled by the fact that the only question you have to ask yourself after considering those factors when we're doing the deferred question is it may he pose a threat to continued threat to public safety, and would continued licensure provide opportunities for further doing that. I think the ALJ was troubled by making a finding one way that seems pretty easy in terms of finding that a deferred can be a conviction, and then going through essentially the same analysis but coming out the other side and saying that the license should not be revoked and that he was okay. But again, I'm speculating. I think the judge should have gone through that analysis that way if this was the result that he wanted and ultimately saw was most appropriate. But
I have a question on that you pointed out on that. Could it be possible that the ALJ was thinking that it's still not clear that deferred adjudications are considered convictions?
well, they're not.
I mean, under the purposes of weighing the evaluation of whether it relates to the affecting the licensing.
Could you rephrase the question?
Yeah,
I'm sorry.
I know, that didn't come across well. I personally have in the past had problems with the deferred adjudication aspect, that it can be used in conjunction with evaluating whether someone should be fit for license. And it's been explained to me since then that it can be considered. So I have my own confusion with that, and I wondered if the ALJ had the same issue, possibly?
Perhaps. I didn't see any major missteps in the road he went down in terms of ignoring any of the laws. I just feel like it's so directly related that he came out the wrong side of that road. And it's troubling to me that something so directly related could be ignored in this case. And perhaps he was swayed by the respondent's testimony He was adamant he didn't really commit this offense, that he pled because he felt it was the safest thing for his family and his continued employment. His employer supported him pleading guilty. His employer came in and said, I don't think he did the offense. I challenged the fact that he went into court and he pled guilty, but now he's saying he's not guilty. And the response I got was that from Mr. Palmer, the employer, was that I was not looking at it through the lens of an African-American man in the situation that he was in and the difficult choices that he was facing. It would be wild speculation, but maybe the ALJ was swayed by that, but also felt hemmed in by the plea. And having to recognize the plea and go through the analysis, I don't know. And the ALJ doesn't make any finding that he wasn't guilty of the offense. I mean, he goes through the analysis as if the respondent did commit the offense, but perhaps personally he was swayed by that.
Well, I think at this point in time, the only thing we can do is speculate without having the AHO here before us. So we have a motion been presented by Commissioner Yurko.
Second.
A second. Basically, the motion is to revoke the license based on findings of fact 30 through 32.
Modifying findings of fact 30 through 32 and
Conclusions of law
conclusions of
14.
law 1416.
14, 16. So, and revoking the license.
And 15 as well, I believe.
And 15, 14, 15, and 16. So, all in favor signify by saying aye. Those opposed?
Okay.
Motion carries 4-1. Thank you, Mr. Thielen. Let's move on to, that concludes our contested cases. Let's move on to the motions for rehearing. At this point in time, we do have someone here, Clarence Kelly. We're going to take your case up right now if you want to come up in here. Oh, go ahead. Let's go on to item 81. Doug?
Go.
Thank you, Chairman, Commissioners. My name is Doug Jennings. I'm Assistant General Counsel for the Department. This matter, Mr. Kelly's matter, arises from an instance in which the Department sought to deny renewal of the Respondent's Class A barber license and revoke the underlying license based on the Respondent's criminal history. In April of 2016, the Respondent pleaded guilty to possession of a controlled substance with intent to distribute, and then the court deferred adjudication of the matter and placed Respondent in community supervision for a term of 10 years. The procedural history of this case is a little different than what we usually see. It resulted from a default order, even though the Respondent initially requested a hearing in this matter. The Respondent, I believe, retained an attorney to represent him at a hearing before the State Office of Administrative Hearings. That meeting was reset at least once, maybe twice. As recently as May of this year, TDLR staff and the Respondent's attorney hashed out some dates, a rescheduling of the hearing for August 9th. When that time rolled around, neither the Respondent nor his attorney showed up at the hearing. At that point, the ALJ remanded the case back to TDLR for default proceedings. Default order was issued, and that's how we are here today. Obviously, there was a motion for a hearing filed, and the Respondent stated that he never received notice of the hearing on August 9th, and that he has not spoken to his attorney since, I believe, March of this year. Now, obviously, I cannot represent any discussions that the Respondent has had with his attorney, but I can state that TDLR staff did work with the Respondent's attorney as recently as May to schedule the August hearing date, and that in May, when that hearing was rescheduled for August, SOA faxed notice of the new hearing date to the Respondent's attorney. And under the SOA rules, that's a proper method of service. And I've reviewed the files, and we do have proof that that was indeed faxed. And so, coming before you today, TDLR itself has made no error that I can discern. The NOAV was sent out properly. There's no allegation that it was not received by the Respondent. What seems to be the case is whether or not the Respondent was or was not in contact with his attorney. We do know that his attorney did receive notice of the hearing date in August. So seeing no error on TDLR's part, we would recommend denial of this motion.
Any questions for Doug?
Oh, I'm sorry. Also, if there are any questions about the record or anything, Mr. Thielen has volunteered to discuss that with you since he was involved with the case.
Any questions? If you don't mind, Mr. Kelly, state your name for the record.
Clarence E. Kelly.
Mr. Kelly, you're in a precarious position. Let me tell you why. In the motions for rehearing, we can only consider those items that would, that you want to bring before the commission and state how there was an error on how your case was decided, whether it was, in this particular case, a default case, or, as you were listening before, the cases that we had before, for contested cases where they actually went to SOA, we consider those items. We cannot consider the facts of the case. We can't hear them here. We don't need to hear them here. And I'm going to ask you to not bring up facts of the case. In this particular instance, all you can tell us as to why we need to reconsider having your case remanded back to SOA for consideration. That's the only thing we can talk about. Okay? Understand that?
Yes, sir.
Okay. Go right ahead.
Okay, well, initially I hired an attorney, Oscar San Miguel. I haven't received notice from him via phone, in person, or correspondence. And I've spoken to him. I haven't even met him in person. I retained him because I looked him up in a phone book, and I asked him, did he represent license, TDLR revocation hearings, and he told me yes. So he wasn't even in the office at the time. So me and my wife, we went over to his office, and we gave him the initial payment that he asked for, and I haven't heard from him since.
Is he still your attorney of record?
I have no idea. I've been trying to reach out and been trying to.
Have you?
That's why I'm here
Have you made
representing.
any move to terminate the relationship with your attorney?
Well, I mean, obviously he terminated the relationship with me.
But you haven't
because-
received notification though from him?
No, I haven't.
Okay,
I
so you
mean,
just haven't had any communication with him whatsoever?
no communication
So
whatsoever.
were you aware that the trial was reset for August 9th?
I was not. I would have been
When's the
there.
last time you talked to your attorney?
I talked to him via phone, and I've been trying to reach out
Okay,
to
but
him.
when
ever
was the
since
last time you talked to your attorney?
March.
In March?
Yeah. Yes, sir.
So you haven't talked to him since then?
Since then, no.
Okay,
I
go
have a
ahead.
question. Okay, what was the first notice you ever received about the violation? For this hearing?
This hearing,
Any hearing with TDLR? When did you first receive notice and how?
I received, well, he said that we couldn't bring up facts that we spoke about.
That's
in-
facts, isn't it?
Yeah, just
When
just
you-
notifications, that's fine.
Notifications.
We don't
Okay,
need to
well,
hear the
well,
case.
I
well,
don't
when
want to
it-
hear the case, just the notification.
Okay, when it comes to notifications, we had a discrepancy over whether they should send it to my house or to the barbershop, where I was living at the time. But since then, I got married, and I live in Mesquite now, so we requested that all correspondence be sent there. So I've only received letters that's stating that the case was still under review.
Okay, hold on. That's, okay. Maybe you can help me, sir. When do we have notice go to the respondent?
The respondent was issued an NOAV, and there's no question that the NOAV, the Notice of Alleged Violations, was served correctly and properly, and the respondent did receive notice of that, and did request a hearing. And so that there does not appear to be a notice issue from anything TDLR has issued.
Okay, great. So I'm trying to build on that is, okay, so was it notice received by him, and then counsel was added afterwards? Because it sounds like counsel came in
I think
after the
Mr.
first
Thielen
hearing.
can answer that question. Come on up here, Trevor.
Trevor Thielen. I don't know the exact date we sent the NOAV. NOAV is Notice of Alleged Violations, which later leads to a request for hearing from Mr. Kelly. He made that request in August of 17, and so we sent him a notice about the hearing date that notice of hearing date was sent directly to Mr. Kelly and received September 7th of 2017. It talks about you may have an attorney. It set the date for the hearing to be in November of 2017. I showed up, our investigator showed up, Mr. Kelly showed up, and at that point decided that he needed to hire an attorney. So he filed a continuance that day, and the judge adjourned it, and then we went on from there, communicating with his attorney.
Okay, and what date was set after that?
We set the hearing date, we agreed on February 27th of 2018. I showed up, my investigator
Okay,
showed
that's
up,
great.
and nobody else did.
Okay, hold on. Okay, but on the when you set that date, would that date have been set when when Mr. Kelly told you he was gonna hire counsel and ask for a continuance?
Well, the judge gave Mr. Kelly a amount of time to hire an attorney and get with us and come up with alternative dates. So the judge left things on November 28th, saying that we needed to get the alternative dates to the judge by December 12th. On December 11th, that's when we got our first fax from Mr. San Miguel saying, I have been retained to represent Mr. Kelly. We talked to him that day, we figured out the alternative dates, and we sent those to the judge that day. And after that, all our communications were with Mr. San Miguel.
Okay. Okay, and then you knew about the February 27th hearing?
Excuse me?
You knew about the February 27th hearing?
Like I said, I haven't spoken to him. I didn't know about
No,
the.
this is the very first one after you just hired your attorney.
No, I hired him 11/28/17, so I didn't know anything about this February hearing.
I mean, because
And-
we're now at 12 months, so at some point
Yeah, I
you should
know.
have been asking,
I
where are
know.
we on this?
He asked me a question a while ago, and I just told him that I had been trying to reach out to the attorney, but I never got a phone call back. I live in Mesquite, he live here, so I got him out of the phone book. I don't know anybody here, so
Did you reach out to TDLR since
no,
December?
I didn't. I mean, they just kept sending me letters. I kept getting letters at my residence saying that the case was under review, so I thought that Oscar was, or Mr. Miguel was doing what he was supposed to be doing or what he was hired to do.
But you never talked to him?
I spoke to him over the phone the first time, and I reached back out to him, and I haven't talked to him since.
Which would be when?
March. Since March. I spoke to him the first time when I hired him, then I spoke to him again in March, and I haven't spoken to him since March.
A little more information that might help shed light on this. He didn't show up, Mr. San Miguel or Mr. Kelly, they didn't show up on the February date. So the judge entered a default at that point and sent notice saying, hey, state good cause for not showing up or you're getting a default. On March 16th, Mr. San Miguel filed a motion to set aside the default, and he said, this motion is filed on the basis that counsel for respondent failed to calendar the hearing through accident or mistake. He didn't explain anything further to that. I objected to it, but the judge said, okay, we'll
Sure.
do this again.
Okay, and then when the defaults were sent, are they sent to counsel and the respondent, or just to counsel?
I think they're just sent to counsel, but GC may be better able to answer that question
I
for a
just wanted-
default that comes through a hearing.
Doug?
The default, the order of default was mailed to the respondent at his residence, I believe.
Would that be the Mesquite residence or the resident of record?
Oh, it's 1914 Colcord Avenue, Waco, Texas.
Okay, and is that your old address?
Yes, ma'am.
Okay, and did you ever notify the agency of your new address?
Yes, ma'am.
Once again, the motion for rehearing simply states that he wasn't given notice of the hearing date. There's been no allegation of there was insufficient notice of an NOAV or a default order or anything of that. So I believe those issues are waived, in my opinion.
That's not, I understand what you're saying, I'm
Okay.
just trying to figure out the extra.
Oh, I understand.
Why didn't we send it to the Mesquite address?
We don't send anything, while the case is ongoing, we don't send anything once somebody's retained to the actual respondent, except for those quarterly letters, which are automatically generated by our system to comply with the state law that says we have to send those out every 3 months.
Okay. But
Everything
did we send
else-
them to the right address? Did we send them to the one that it was changed to, or did we send it
I
to the
don't-
old address?
I don't know where the quarterly letters were sent, but the, everything about the ongoing case was just to Mr. San Miguel, as I understand it, and it was being sent by SOA, because once we've gotten Mr. Kelly into court and we're not further filing any notice of hearing in the case, then all notice about further court dates is coming from SOA. And it is proper under the rules for them to only serve the counsel of record with those notices until we
Absolutely,
get
I
to the
agree,
end.
absolutely. I don't think y'all have done anything wrong, but I'm just trying to understand. You said that there was a letter sent, but it was sent to his old address, correct?
Mr. Chairman, if I may, I just was given a piece of information that might be helpful. I've been informed that our TDLR system still shows the Waco address as the address of record.
Yes, I was, thank you, Brad. I was about to state that I just looked at the default order, and that shows it is his address of record.
Okay, so did we never get the new address from him? I mean,
I can only
trying to
presume
figure
that we
out-
did not.
Okay.
Something bigger than this, Mr. Kelly.
Excuse me.
Mr.
I
Kelly,
get-
just wait one
Oh.
second, okay? Commissioner Figueroa would like to.
When in part did you're managing your attorney, right? Your attorney responded. I guess you didn't know he responded on your behalf.
I know he responded on my behalf because when I retained him, he told me he was gonna send a letter to Mr. Thielen that he was. So that's how I know
But
that
he
he's,
responded again to us saying that he made the mistake about putting the wrong date on his calendar. So
okay, but
you know that he responded on that.
I have no idea about what he discussed with them. All I know is what he discussed with me. And then as far as the addresses go, when we were in court that day, Mr. Thielen brought that up, so I gave him the new address to send it.
You
So
gave it to who?
Mr. Thielen.
Okay, it's
So-
not his responsibility to
I
get
know
your
it's not his responsibility, but he just responded a minute ago, and he said that the address on record was the 1914 Concord,
In Waco.
where the 1501 Lone Star Mesquite is where they were sending the letters to.
That SOA was sending the letters to.
I have
SOA,
no-
or you say you got letters in Mesquite. Was that from SOA or was that from TDLR?
I have no, I think it was from TDLR.
Okay. The reason I'm saying that is because we have your record, address of record of being the Waco address. That's the only place
Okay.
we'll send them. SOA might send the letters to to your Mesquite address, because if that's if that's the address that your attorney gave them, that may be what you're getting, not from TDLR, but from SOA. You need to call in or make a formal change with TDLR that your address is in Mesquite.
Well, I thought I was making a formal change when they asked me, because the discrepancy came up when we were in the meeting, and the judge asked Mr. Thielen, where should the mail be sent to? And at that time, me and my wife provided them with the 1501 Mesquite address. So when they were sending letters and they were giving me updates quarterly, that's who I thought I was getting it from. And I thought that
And I'm
was the
assuming that
record
came
was
from
on
SOA?
file.
I
The
don't
letters-
really remember the specifics. I'm going to take him at his word that he told me in November 2017, when we showed up for the first time, that he had a new address. But I think it's important to consider what was the effect of, let's say I didn't translate that to our case file to make sure that that address was updated. Nothing after that would have been sent to him until we get to the very end. And the only letter after that that was ever sent to him was the default notice after SOA's whole role in all of this was established. And apparently the default letter got to him because he knew to file a motion for rehearing, and he's here today.
Where'd you get that default letter at?
Well, my brother works at the barbershop,
Is
and
that
he
Waco?
called.
The
Yes,
Waco address?
He worked there at the barbershop. I was living there and staying there at first before I was married.
Do you
So my
understand
brother-
that the moment that it went to SOA, TDLR stopped sending you letters? Do you understand that part?
I understand what's being translated to me now, but
Okay, but
ahead-
during that time frame, you didn't.
I didn't understand it
Okay.
then. Yeah.
All right. And so then when you received the next letter from TDLR, it was basically saying that there was now a default case.
Yes,
Okay.
But you showed up at court at some point, right?
yes, I did. November. And directly, I hired an attorney that day because I'm not from Austin. Don't know anything about this place, so me and my wife stayed there all day calling people, in the phone book until we found Mr. San Miguel.
I think you may have a problem with Mr. San Miguel. Any other questions, comments? I can tell you on my part, Mr. Kelly, I think that there was a lot of dates floating around here that we've been talking about. In my opinion, ultimately, the fault lies with your attorney. That's my opinion. Because I think that once this all happened, that we stopped sending you letters, and notification from Sol was sent to the attorney of record, and he's not returning your calls, and he's not answering your calls. So in my opinion, you got a problem with your attorney. So I would say that while you're down in Austin, you might want to pay him a visit. It's my opinion that we go ahead and give you, it's my opinion that I'll vote to give you the motion rehearing just so you can start all over again. But this is the only, in my opinion, for me, this is the only bite that you're going to get. Okay. Any further questions or comments?
I'm saying, he's your employee, Kelly. Your attorney's your employee. Don't be intimidated by those guys. You need
Okay.
he works for you, and he's got you in this position. You yourself, and some point, some switch had to flip and say, I hadn't heard anything, something's wrong. Because it just didn't disappear, right? And I granted, we might want it to disappear, but it didn't. Being all said, I prefer you at least have your day. So, I'll move for the motion we're hearing.
We have a motion.
Second.
Second. All in favor signify by saying aye.
Aye.
Those opposed? Motion carries. Staff will get with you. You're going to have another bite at the apple and start all over again. But again, you got a problem with your attorney. You need to get that settled.
Okay.
All right, but we're going to give you another chance at it.
All right, thank you.
Thank you. Commissioners, real quickly, you can stay right there.
Okay.
Commissioners, real quickly, let's move on to the appointments memo. The reason is I'm going to have to cut out of here. I've got a flight I've got to catch. You have before you on the appointments memo, and let me name this off, on the Combative Sports Advisory Board to appoint Eric Garcia and Keith Underwood. The Drivers Training and Traffic Safety Advisory Committee to appoint Michael Kelly. Name sounds familiar because he was a former employee of ours. To appoint on the Massage Therapy Advisory Board, Roberta Hudson. On the Registered Sanitarian Advisory Committee to appoint Aaron Dunn. On the reappointments to, on the Architectural Barriers Advisory to reappoint Philip Pierce as the presiding officer, Jim Durham, Michael Olson, John Rickard. I want to pass on the Elevator Advisory Board, and I will bring that to you later, so it's not a part of my recommendation to you at this time. And on the Texas Waterwell Drillers Advisory Council, John Pyborn. So if you would just exclude the Elevator Advisory, I would ask that you accept the appointments and reappointments to the advisory boards.
Need a motion for that?
Yes.
I'll make that motion.
Second.
We have a motion second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Commissioners, thank you. Again, if you've got anybody in your area or know of somebody maybe interested in serving, have them reach out to Mary Winston, who's not in the crowd, but she's here. Have them reach out to her or anyone in the Appointments Advisory Board and have them fill out an application. It's also online. So, all right, let's go back to item H2, which is Vance Service Private Investigators. Is anyone here representing Vance? Go ahead.
Thank you, Chairman. Again, Doug Jennings, Assistant General Counsel for the Department. This matter resulted from a default order in which the Department assessed administrative penalties against the respondent totaling $5,100 based on alleged violations of a number of VSF rules. In the motion for rehearing, the respondent stated that the notices were improperly addressed to Charles H. Vance, registered agent, and the motion for rehearing states that the company's registered agent is named Charles R.K. Vance, not Charles H. Vance. Charles H. Vance is a retired member of that company, apparently. Despite the respondent's argument, we believe that notice was proper in this case. While one of the notices, there were two sent out, one of the notices was addressed to Charles H. Vance, registered agent. That notice was neither delivered, we cannot find a record that that notice was delivered, and it was not returned to TDLR. However, an NOAV was sent to the business's address of record, and was signed for by Eugenia Vance at 8:22 a.m. on June 27th, 2018, and therefore Notice was in fact received, and we have evidence of that. And because notice was proper and that is the only error alleged, we would recommend denial of this motion for rehearing.
Are there any questions? Chair, entertain a motion. Do we have a motion?
So moved.
We have a motion. Is there a second? We have a motion and a second. All those in favor, please signify by saying aye.
Aye.
The ayes have it. The motion carries. Continue on, Doug.
All right, thank you. This matter, the motion for rehearing filed by Casey Douglas, results from a default order in which the department assessed administrative penalties against the respondent totaling $3,000 based on the respondent's alleged failure to maintain the required insurance for the VSF she owns. In the motion for rehearing, the respondent states that she has had a number of serious medical issues since 2015 and never returned to the facility. We are construing that argument to also maybe argue that she thought she no longer needed a license after that point. However, this enforcement action resulted from an inspection of the premises, and the VSF was open for business at the time. The investigator actually met with an employee on site and asked for the insurance documentation. The employee couldn't produce that, and in further requests to the company was unable to provide proof of insurance. Notice was proper in this case. The NOAV was sent to the respondent's permanent mailing address of record, and that was reported by the USPS as delivered on February 26th. Because there's no allegation of error on the part of the department, we would just ask that you deny this motion for rehearing.
Okay. Is there anybody here representing Casey Douglas or Douglas Towing and Recovery? Okay. Does anybody have any questions of the department? No? Hearing none? The chair will entertain a motion.
So moved.
We have a motion. Do we have a second?
Second.
We have a motion and a second. All those in favor, please signify by saying aye.
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 The motion carries and the ayes have it.
Thank you.
Thank you. Okay, who's on the hot seat? Staff reports. Do you have anything?
How much time do you have?
How much time as these guys will give you?
Carla James, TDLR. Pamela is reminding me that agenda item I has not been looked at yet, and that is an update on the motion for rehearing process.
Mr. Chairman, this is Brad Bowman, General Counsel. If that's something you'd like me to cover, I can do that now.
Brad, if you would, please.
Yes, sir. This is just an update for the commission on the process that the commission has authorized the department to handle motions for rehearing in a little bit different way. There are some categories of motions that staff has been authorized to dispose of in certain circumstances. As part of that procedure, we have a report that we bring to the commission every meeting, and that report is in front of you. There was one motion for rehearing that did not come to the commission, and that's on the report. You also have a copy of that attached, and that motion was granted by the executive director. That's one of those situations where the commission has authorized the staff to take action if general counsel's office and the executive director agree that there was some error. We can go ahead and dispose of that rather than waiting for the commission meeting. That's the only one of those that's on. Yes,
I don't
Commissioner.
believe I got the report,
Okay, it should be in the materials.
because I didn't get the materials
Oh,
part
okay.
of the meeting.
We'll get a copy for you.
Okay, that'd be great. I have a question out of curiosity, just, the hearing that we actually granted the motion, would that normally have come to us under the new procedures?
Yes.
Or would that possibly not, is it a chance that it may
Well,
not have?
We are, since we're under the new procedure, the ones that we brought to you today are the ones that, the kinds of motions that we would bring to you.
Great, so that would have still come?
That would have still come
Okay.
to you, yes.
So we're in the process of reviewing those procedures, and could we get that to Ms. Yurko? And and any others that
Yeah, 'cause I
might
don't
be
have-
interested in talking about the hearing process and where we are?
Absolutely, and I'll get with Commissioner Yurko after the meeting, and we also intend to keep this item on the agenda going forward so that you can monitor the progress of it, and we can make any adjustments going forward as we need to. I'm available to answer any questions.
Thank you, Brad. Carla?
Thank you, Chairman. Carla James, TDLR. Don't have a lot out of the ordinary to report to you all. Very busy as usual, preparing for the legislative session, allowing staff, of course, to take as many holidays as we can cram in before session starts. But nothing truly out of the ordinary to report. Brian has testified at a couple of hearings in preparation of session at the Senate Business and Commerce and yesterday at the licensing. And we have received some high compliments from both of those committees, so happy to report that.
I think it's just the wording.
It's a new thing.
You want to ask Brad?
Yeah. Is it,
Brad, we have a question for you.
Yes.
I noticed, and this is just being nosy, on the, because it's under yours, under executive session number 3, it says, discussion of personnel matters, including but not limited to discipline and dismissal of the executive director. I notice that keeps showing up on our agendas. Is there a reason why that keeps showing up?
My understanding, it's Brad Bowman, my understanding is that's a standing item that we've been asked to place on there.
Okay, it just seemed unusual, so I was like surprised it was there.
It has been on the agenda for some time. It's been basically just a standing item with that same wording. For probably a year and a half at least. I'd have to go back and look, but it's been for quite some time.
Is that simply because we discuss personnel matters in executive session? Or is it just?
Yes.
This looks like it's
It-
directed exactly to the executive director.
It's including the executive director, and it just, essentially, it's a standing item that gives you that authority anytime at any of your meetings to discuss that. It's not limited to the executive director, but it's, if the commission does discuss an issue regarding the executive director, that has to specifically be listed on the agenda.
Could we possibly take it off where it doesn't just identify the executive director and keep it more as a generic thing of discipline and dismissal as opposed to of the executive director?
We could. We certainly could.
Is there a reason where you're going with this?
I all the years I've been on here, I just thought that was unusual that showed up the last 12 months. And so I just thought, you know, to me, it seems a little disingenuous. So I'm trying to figure out what it's still doing on the, either we're going to address it or we're not. And if it's just on there as a safety net, I just don't think it's
So in the most
appropriate.
in the most generous light, we could say, I mean, because it talks about the duties, we could, I mean, that could be just a discussion about his duties as well, correct? Not necessarily discipline and dismissal. I mean, it's just everything. It's kind of a catch-all in a way.
And we could certainly tailor the agenda item for each meeting as to what you may or may not discuss for that meeting. So I'm certainly open to however the commission wants to word that.
I mean, because
or
I'm
not.
guessing if we're supposed to put it on there, I think it needs to be genuine as opposed to just a blanket on there every month, is what I was thinking. It just, to me, kind of defeats the purpose. So if it's not something that's legitimate, then we probably need to think about being more accurate.
Understood, and if I,
So why don't you talk to the chair about that going forward?
Yes,
and y'all
yes,
can
sir.
come up with some adequate wording that's.
That'd be great.
I will do that and the executive office as well.
Okay, great. And you'll touch base with Deborah about the other issue,
The motion for rehearing
motion
issue?
for rehearing issue. Let's not let that
Absolutely,
get cold,
yes.
okay?
Yeah, thanks.
Well, thank you so much, everybody, for the hard work you put in. Are we done, Carla, with your reports? Thank you for everything that you've done. The session is going to start here soon, and like Carla said, it's going to be tough, but we do it every time, and y'all do just a bang-up job, better than anybody else, I think. And so, thank you for everything, and with that, the meeting is now adjourned at, my eyesight fails me,
12:09, sir.
12:09.
Wait,
Thank
you're
you.
done?
We're done.
Oh, God, that's awesome.